Rule 215, sub-rule 3, it says that a member dissenting or members. And the reasons are in this report, Madam Speaker, you'll see. If I may address you briefly, in the committee...
I am giving you 35 minutes.
This is
all of you. Honourable members, before we continue to...
Political history of Uganda. Honourable members of Parliament, please pay attention to the contents of this speech attributed to President Yoweri Kaguta Museveni in the early 1990s. This is what he said. I open the quote. Depending on the nature of the state, in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It is not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave trade period, enslaved people were owned and disposed of like chattels, and it was perfectly legal to own a slave. The NRM government is strongly opposed to having laws on our statute books which serve the interest of the minority against the majority of the people, or in which, any way, promote to serve the injustice or advance backward interest in our society. We close the quote. The minority shall, where necessary, refer to the speech above for the purpose of reminding ourselves as legislators and fellow Ugandans. And 4, of Sovereignty Bill 2026, the co-chairpersons violated several provisions of the Rules of Procedure of Parliament of Uganda. Rule 135 of the Rules of Procedure is instructive on reference of a bill to the committee as follows. Sub-Rule 1, whenever the bill is read for the first time in the House, the bill shall be referred to the appropriate committee appointed under these rules. Sub-Rule 2, the committee shall examine the bill in detail and make all such inquiries in relation to the bill as the committee considers expedient or necessary, and report to the House within 45 days from the date the bill is referred. 3, except in the cases of very minor amendments and subject to Rule 138, all proposed amendments to a bill referred to the committee shall be presented to the committee by the person proposing the amendment, and the committee shall scrutinize the amendment together with the bill. 4, the committee may propose and accept proposed amendments in the bill as the committee considers necessary, if the amendments, including new clauses and new schedule, are relevant to the bill. The minority observes that the committee violated sub-rules 2 and 3 in as far as it did not examine the bill in detail and further did not make all such inquiries in relation to the bill. In the view of the minority, the decision of the committee through a vote on a motion by Honorable Fox, Odur, or Yelowo for an omnibus adoption of all clauses of the bill and the amendment by the learned Attorney General without examination and inquiry violated Rule 135. The minority, Madam Speaker, also observed that the Protection of Sovereignty Bill 2026 was proposed by the Minister of Internal Affairs, Major General Retired Kahinda Otafire. Sub-Rule 3 restricts the latitude to propose substantial amendment to only the mover of the bill, which is the Minister of Internal Affairs. Only minor amendments may be proposed by any other person who is not the proposer to the bill. With all due respect, the learned Attorney General proposed 18 amendments, all quite substantial in nature, which amendments the majority unilaterally adopted and relied on to pass the bill in the committee. The committee sought to have rejected the committee ought to have rejected the substantial amendment proposed by the learned Attorney General outrightly. To even make it worse, Madam Speaker, the new amendments were laid before the committee in form of a new bill. Rule 135, Sub-Rule 1, confines the committee to a bill read for the first time in the House and referred to the committee. The committee is stopped from directly receiving bills not read in the House and referred to it by fraudulently bypassing this House and smuggling an amended version of the bill to the committee, an illegality that goes to the root of parliamentary procedure and practice was committed and cannot be cured by any explanation at all. Madam Speaker, the minority further observes that no sooner had the learned Attorney General purported to present the amended Protection of Sovereignty Bill 2026 to the committee at about 12 noon on Thursday, 30th April 2026, than His Excellency the President, through his address to Ugandans at about 4 p.m. on the same day, withdrew instructions from the learned Attorney General. Instead, President publicly assigned Honorable Dennis Amson Obua to ensure that the bill concentrates on what he calls sovereignty of policy decision-making. In the practice of law, there is nothing professional as humiliating as a client withdrawing instructions from you and sharing it out with the public outright. No wonder, since then, neither the Attorney General nor the Minister of Internal Affairs ever attempted to appear before the committee or the House. The House must therefore not entertain the two on anything to do with the Protection of Sovereignty Bill 2026, since the President withdrew the vote of confidence in them. The minority, Madam Speaker, formed the view that Honorable Obua Hamson, having been given fresh instructions as per the written expression of the President, ought to have immediately sought audience with the committee to present the instructions given to him. Was it an instruction to withdraw the bill? Or what was it? Despite the insistence of the minority to invite the Honorable Hamson Obua under Rule 135, Sub-Rule 2, to make all such inquiries in relation to the bill, as this was the most expedient, the co-chairpersons, Honorable Kajwenje Wilson...
Honorable Jana, sorry for interruption. Might not procedure. Flavia, points of departure, not a debate on the procedural ways.
That I had.
Which one? Which one?
Under subheading 3.1, I said areas of dissent and statement for reasons of dissent as provided in the rules. The first was violations of the rules of procedure of Parliament. And I am explaining under Rule 135 that the committee ought to have examined and on its own move to go and inquire, to make inquiries. And my point is, having come to the attention of the committee that Honorable Obua Hamson was assigned, the committee ought to have moved itself to request Honorable Obua to come and substantiate. It goes to the root of my dissent, Madam Speaker.
So the committee instead went to Honorable Obua? Or they should have?
Thank you, Madam Speaker. The co-chairpersons were evident. Madam Speaker, this is important. The co-chairpersons, Honorable Kajwenje Wilson and Honorable Baka Mugabe Stephen, were evidently partial, hostile, and continuously switched off the microphone of members in the committee they perceived to be against the bill. Contrary to the established practices of availing physical copies of submissions of stakeholders to members of Parliament at the retreat, members of Parliament were instead told to physically get copies to members of Parliament. Instead, were told that physical copies could not be availed since Parliament was on a weekend. The views of Madam Speaker, views of selected stakeholders were instead sent to members on WhatsApp to read on their phones. Of the bill when passed. In addition to the requirements under subsection 2, the certificate of financial implication shall indicate the impact of the bill on the economy. Notwithstanding subsections 1, 2, and 3, a certificate of financial implication shall be deemed to have been issued after 60 days. The minority examined the certificate of financial implication issued on 15 April 2026 by the Ministry of Finance, Planning and Economic Development, signed by Amos Lugolobi, MP, Minister of State for Finance, Planning and Economic Development. In the certificate, under paragraph 5 on impact of the economy, the Honorable Lugolobi states as follows: the proposed bill is expected to strengthen Uganda's policy autonomy and national security architecture, improve coherence in the management of foreign aid and foreign-funded activities, and support stability in governance and public order. These outcomes are expected to contribute to a more secure environment and implementation of government programs and long-term national development. Befallen this country, that the entire ministry responsible for finance, planning and economic development does not know what constitutes an economy of a country called Uganda, and therefore are unable to articulate the impact of the bill to the economy of Uganda. The minority observes that instead of assessing the impact of the bill against well-known parameters such as GDP, sovereign debt, debt to GDP ratio, balance of payments, central bank reserves, interest rates, inflation, exchange rates, rate of growth, etc., alien parameters form the basis of the assessment. The observation by the majority report that the certificate of financial implication met the statutory standard.
Honourable members.
Let me just put on record.
Yes.
This minority, which I wrote, is actually...
Let's capture all the all what has been in all the minorities.
This is what exactly
so how much?
in the committee.
Let me give you 2
had.
minutes. Let's give you 2 minutes.
This report I have is 40 pages.
Let me give you 3 minutes to summarize.
And in the committee, the same treatment, Madam Speaker, we were not heard. That's why I'm bringing this issue. I'm appealing to the House.
I have actually given you the same amount of time, 2 minutes. You conclude.
Madam Speaker, I want to put on the record that I cannot conclude in the 3 minutes you have given me, but I appreciate it. If it is your ruling that this report stops at this level, I have no problem. I respectfully submit, and then I can leave, because there is no way I can. And I wanted just to finally, because as you also know, this may be possibly the last time some of us may be in this parliament. So I wanted you to protect that constitutional right, that little window that the people gave me to be in this house, to represent them. I just plead of you. I may not come back, ever. But that constitutional right for me to present, I wanted to ask that you give me.
Jonah. Now, Jonah, I have always told you you're one of the people I will miss in this house. I am giving you an additional 5 minutes, and all the other minority reports, we will capture what is in your minority report, because the time has been taken.
Right Honorable Speaker. Thank you so much, Right Honorable Speaker. I want to now go back to the report, but let the record capture that when I appeared in the committee, and you have designated me, Madam Speaker, as a member of Parliament to sit in the Committee of the Legal. In the joint committee, I was not given the opportunity. The same treatment, and that's why I thought this House would allow me to present. So with that, let me just put on the record that that the 5 minutes that you have given to me is not enough for me to present this. And I thank you, and probably take the opportunity to conclude by wishing members who are going to return to the 12th Parliament good luck in their deliberation and representations. I know next week people are going to swear in. I want to wish you all the best. But without prejudice, if the committee proceeds to committee stage, there are amendments that are also attached here.
Yes.
I beg that I will be given time to move those amendments, Madam Speaker.
So you're putting a motion for committee stage.